I get asked a lot about hollow point ammunition. Mainly US Law Shield members who come to my seminars want to know if using hollow points is something that could get them in trouble if they use it in their carry guns to defend their lives. Now, regardless of your conclusion from this video, regardless of what you hear in terms of criminal liability, regardless of what I know, I still recommend hollow points for personal defense use. In simple terms, hollow point ammunition is a round that has, well, a hollow point, like a steep bowl carved out of the bullet's tip. This causes the round to expand after hitting a target, increasing temporary and permanent wound cavities, making the round more terminally effective against unarmored targets. And because I know you're going to ask, my research leads me to conclude that Federal HST seems to be a top performer across the line, regardless of caliber. I've got no affiliation with Federal, just a big fan of their work, and I think the HST is wonderful. Gel tests that I've found online consistently show HST is a top performer. It's specifically because of the grisly nature of the hollow point's effectiveness, as well as its notoriety that law-abiding gun owners have concerns about how a prosecutor will make them look if they use hollow points and they shoot somebody, perhaps kill somebody while defending themselves. A defense lawyer should frame hollow point ammunition as a responsible gun owner choosing the most effective tool, a tool used by law enforcement, mind you, for the job. Could the state try to paint you as a sadistic killer using a weapon for causing the most damage possible? They've tried before. Let's start with the good news. Most of the cases I've seen in my research don't involve Joe homeowner minding his own business and shooting a robber. More often, it's sketchy circumstances. Let's talk about Culp versus state of Florida. It might be God's favorite state, but every now and then, even Florida gets one wrong. In this case, the defendant, Culp, told authorities that he was visiting the house where his 14-year-old daughter lived with his ex. Now, allegedly, his ex was also living with a man who he knew as a violent crack cocaine addict, or as we call them in Florida, citizens. The man was a concealed handgun permit holder. He carried a pistol in a shoulder holster because it was more comfortable for him while riding his motorcycle. Wow, the only way this case could get more Florida is if an alligator just snapped open a bag of oranges behind the Publix before shit popped off with Crackhead. There were conflicting stories, but Motorcycle Dad said that Crackhead and his buddy's crack status unknown, attacked him with a knife, so he cracked off the rounds as a warning. The three men struggled over the gun, and the crackheads actually took the gun from Motorcycle Dad. Motorcycle Dad was convicted of attempted murder. Interestingly enough, at his trial, one of the men involved in the fight with Motorcycle Dad testified that when they took the gun from him, they found that it was loaded with hollow points. And he testified that hollow point bullets, this is the crackhead, the hollow point bullets are made for killing, over defense counsel's objection. On appeal, the Court of Appeals held that this was improper testimony from an unqualified, possible crack rock addict layperson that prejudiced the right to a fair trial, because in an attempted murder case, the intent of the shooter is what the case is all about. Allowing jurors to hear associate crackhead testify as to the purpose of a hollow point in open court was unfair. Now, impliedly, this means that perhaps the Court of Appeal would have allowed a non-crack enjoyer expert to testify that hollow points are for killing. And that's exactly what happened in Long versus Yates. Now, in this absolute sitcom of a case, which is like Trailer Park Boys meets Napoleon Dynamite, David Long lived with his brother Ken, who was a master martial artist. David was a drunk, but he was a cleanly drunk. And his brother and him would fight because Ken wouldn't do the damn chores. One day, David goes out to mow the lawn with a rum and coke, seriously, that's in the record, and starts screaming at his brother from outside the house because he's pissed off about mowing the lawn. Ken comes outside, the fight escalates, but Master Ken harnesses his chi, and he goes back inside to watch his soaps. It's at that point that David goes inside, drunk, grabs a revolver, and shoots his brother in the stomach while Ken was just chilling on the couch. Side note, nothing quite annoys me like people who get annoyed because you're not annoyed. There are some people who will get so mad that you're not mad that they'll shoot you over it, and frankly, I don't know what to do about those people. Anyways, David shot Ken with a hollow point .38 special and was convicted of aggravated battery and attempted murder. On appeal, he argued that it was misconduct for the prosecutor to refer to hollow points as cop killer bullets repeatedly during the trial on the attempted murder charge, including during closing arguments. So in the closing argument, essentially the prosecutor saying, look, this guy definitely attempted to murder his brother, because otherwise why would he have these cop killer bullets in his revolver? The state put on an expert witness, a police detective, who testified that hollow points are often called cop killer bullets because of their increased lethality. David Long argued that the description of hollow points as cop killers was unfairly prejudicial to his case. The Court of Appeal not only disagreed with Long, but they flat out agreed with the state, finding that, quote, the government's expert was correct that hollow point bullets are commonly known as cop killer bullets. The Court of Appeal even cited two other opinions which said referring to hollow points as cop killer bullets is not prejudicial to the defense. Thus, there's apparently a risk that prosecutors could try to characterize your use of hollow points as cop killers, and there is precedent out there that would support their using this terminology through ballistic expert testimony or even the testimony of a qualified law enforcement officer. However, I'd encourage each of you not to overreact from this information. Again, in both those cases, we looked at what happens to be a general theme in cases with hollow points or just for killing people testimony cases. The factual circumstances are suspect, and it seems like hollow point testimony is generally used to support premeditated or attempted murder charges that require the state to show that there was a specific intent to kill. If David didn't intend to kill his brother, then why did he use cop killer bullets? But for most of us, the more realistic scenario is going to be when we're attacked in our own homes or in public by a stranger, which is not what happened in either of the two cases I just talked about today, in Culp or in Long. The Culp and the Long cases both involved defendants who attacked people in the alleged victims' homes, which lend themselves factually to being attempted murder cases versus self-defense. I guess the lesson here is that if you're trying to accidentally defend yourself with premeditation at someone else's house, maybe leave the hollow points at home. Or you guys could just bring the RIPs. You guys know RIP ammo, right? I don't know if they're still in business or not, but it's a company that makes a typical overhyped, gimmicky gun product that, between being called RIP or RIP ammunition and that acronym standing for the radically invasive projectile, it's a prosecutor's wet dream for someone to use one of these. And I wouldn't use RIP bullets if they were the Indian Tomahawk rounds from Who Framed Roger Rabbit. I don't care. There's just too much potential for exploitation by the prosecution. It would look bad to a jury. I thought for sure there had to be at least one decision involving RIP ammo, and sure enough, there is one reported decision. In 2017, Bob Martinez shot his cousin with a homemade Tech-9 loaded with RIP ammunition while his cousin was asleep with his girlfriend. Dr. Bob got his PhD from the streets and his law degree from Hard Knocks U, because this guy waived his Miranda rights, told cops that he shot his sleeping cousin in self-defense, and said that he bought RIP rounds because they are useful for, quote, putting someone down. This is a guy who bought RIP marketing hook, line, and sinker. So I guess big ups to the RIP marketing team. This is your customer. Unfortunately, the ammo did not perform to Mr. Martinez's expectations, apparently, because his cousin survived. Martinez also said, and this again is a quote, that he located his cousin after a search of the perimeter at his grandma's house, and that he missed the money shot, his words, or the headshot, which he was upset about because it seems like he was telling officers that he felt like he would have gotten away with literal murder if his cousin would have died. He thought he was that smart. Martinez was found guilty of a number of crimes, including attempted manslaughter. Directly from the opinion, he confessed to shooting Smith during his interrogations and at trial. He admitted that he wore a bulletproof vest, carried a ghost gun Tech-9 loaded with RIP bullets designed to put someone down when he went to his grandmother's house to find his cousin. When he arrived there, he did not go to the main house to see his grandma, but he instead immediately walked to the shed behind the house where Smith and his girlfriend were staying. Although he knew that he had shot Smith, he left without rendering aid, without calling paramedics. He later admitted to officers he wished he succeeded in killing his cousin. Did this guy's conviction stand? Lock in your votes now. Guys, come on. You know this dude's still got his ankles pinned behind his head in the penitentiary. So you can make arguments for or against hollow points after watching this video, legally speaking, but there's one thing that there's no debate over. Confessing to attempted murder is typically inadvisable if you're trying to avoid going to jail for attempted murder. That tip's free, but I'm not your lawyer, and this is not legal advice. At the end of the day, I'm going to go with the most practical solution that I can use to defend myself, and I'm going to make sure I have a lawyer who can explain to a jury that, ironically, cop killer bullets are the bullets used by cops, and that they potentially reduce the risk of injury to bystanders and are more effective. But I hope you found this information helpful for making your own decision.